Mr. Sease.
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court. My name is Matthew Sease, and I represent the appellant in this matter, Adam Dahl. Today we ask this Court to follow federal court precedent and the majority of the estates and find that when an indigent defendant makes an application for expert services, in particular, in this case, a private investigator, that he has the ability to have that hearing and that determination of whether or not he should be allowed to have one in an ex parte, non-adversarial proceeding.
You say federal court precedent, but the federal rule allows for ex parte. What was the state of the federal law before the rule was written with ex parte in it?
I don't know that, Your Honor. That rule was originally written in the Criminal Justice Act of 1964, and it's been applied ever since that, and it hasn't been changed originally. And I don't know if it's specifically addressed, but the legislative history at the creation of that, as referenced in the cases that I cited in my brief, stated that the purpose of having the ex parte language in that federal rule was so that the defense did not have to disclose, or the defendant did not have to disclose its defense in front of the prosecution. And so I think it's showing, I don't know specifically what the case law was at that time, but the intent at the time of drafting was to address that specific issue. And additionally, the federal cases aren't specifically mentioning the due process and the Sixth Amendment rights that we're alleging in this case. But they do hint at it, and the case that I cited in my brief, U.S. versus Abreu out of the First Circuit, it states that it's reversible error to not have the ex parte hearing, and then they also discuss the reasons why that is an issue is because it's penalizing the poverty to not have an ex parte hearing regarding that. And the reason why those federal cases are important and illustrative is because this court, 40 years ago in State versus Williams, said that Iowa's Rule of Criminal Procedure 2.20 sub 4, which allows for indigent defendants to apply for expert services, should be following the federal guidelines and look to it. And specifically, this court stated that it would be prudent for district court judges to look to that. Additionally, in State versus Coker, this court also said that an individual, in interpreting the proper interpretation of Iowa Rule of Criminal Procedure 2.20, it's similar in both purpose and language to the federal precedent. So the federal precedent provides some guidance for the proper determination of this rule. Additionally, I think in Ake versus Oklahoma, there is reference that when an individual is applying for psychiatric services, that an individual should have that hearing ex parte. Again, that's under the, I believe that was under the Due Process Clause.
Before the court convenes an ex parte hearing, what does a defendant have to show to entitle them to the ex parte hearing but not give away their defense?
I think, Your Honor, that what needs to happen is that the individual should file a motion that says, I want to have an ex parte hearing regarding expert services. And I think that's all that is necessary, and I think under the rules that's what it requires. And then you would have a sealed ex parte application that outlines the specifics for what expert you want to have.
Doesn't it have to be necessary? I mean, you have to have some showing, because otherwise you might have everybody just asking for an ex parte hearing because they want to hire an investigator.
But there's two, it turns into two separate issues, and I think what I hear, Your Honor, there's the split in the authorities, right? There's the majority of the states, and I think under the federal statute, that say you have an absolute right to an ex parte hearing, and then you outline why you think it's necessary to have those services. And then there's states like Louisiana in the State versus Touche case that says in order to get that ex parte hearing, you have to establish why it's necessary to have the ex parte hearing. Well, I think if you look at this case, it shows why that's not necessary. The state and the court ultimately found that an ex parte hearing was not necessary because there wasn't specification as to why it was necessary. But in a private investigator case, what else is the defense attorney supposed to do other than say, I want to have the private investigator investigate the scene, investigate witnesses, which is what trial counsel did in this case. Anything beyond that causes into question the effective assistance of counsel claims and the attorney's duty of not disclosing confidential information to the trial court, or excuse me, to the other side, and inhibiting the defense of the trial.
Say a little bit more here without spilling the beans.
In this case, I don't believe so, Judge, or Your Honor. I think that there isn't anything else to say that will not divulge this defense tactics. I want to interview witnesses, and I want to interview or have him review the area where it happened. And anything beyond that, I don't think you can say anything else without potentially divulging those client confidentialities and giving some sort of a look into what the defense strategy is. So I don't think that there is anything else in the private investigator sense, particularly, that would be applicable. You could make that argument for other expert services as well. So for like a ballistics expert, I don't think you would need to, if you haven't done reciprocal discovery or you haven't have an obligation to provide that information, and you want to make the ballistics of a weapon an issue but don't want to alert the state to it, you should just file your application that says that you want to have that ex parte hearing and allow it to go forward and outline it to the district court judge to make the decision of whether or not it's necessary for your defense.
Are you then just specifically asking that a hearing occur in the presence of the state as well, and then at that point in the hearing where you present your case and you need to disclose confidential information or whatever it is, then the state would be excused from the hearing?
I don't believe so, Your Honor. I think under the majority of the states and under the constitutional principles that we've outlined, that all that's necessary is that the defendant has to file an application that he wants to have an ex parte hearing regarding expert services. And that's all it needs to say. And then the court should set a hearing about that. And then at that time, it's outlined everything. But anything beyond that, I don't think that it's proper for the state to even object to the ability to have the ex parte hearing in the first place. If you look at Strickland versus Washington, the seminal case for ineffective assistance of counsel, the Supreme Court stated that the government violates the right to effective assistance of counsel when it intervenes in certain ways with the ability of counsel to make independent decisions about how to conduct the defense. And when the state is saying, no, you can't have a private investigator. No, you can't even have a hearing to determine whether or not you're having a private investigator. They're intervening with that defendant's decisions about how to confer with the case, because you're putting the defense attorney in a position in which they have to weigh how much I want to testify or how much I want to tell the court about what my clients told me about specific issues versus how badly do I want this expert. And I think that you run the risk under both under the procedure where we discussed, where you have to ask for the ex parte hearing first, of a ton of post-conviction relief claims where the defendant is going to say, you didn't disclose enough information for me to get an expert. Or you're going to have them say, well, you disclosed too much information and it affected our ability to testify.
I mean, the reality is, and I've worked on criminal defense matters, both being court-appointed and not, sure. And you're under a lot more constraints being court-appointed than otherwise. This is not the only one.
Sure.
And I don't think we've said it's a constitutional problem that there are some differences between court-appointed representation and retained counsel.
That is correct, Your Honor, but it gets to the point of whether or not that individual, that indigent defendant, is having to disclose defense strategy that a non-indigent defendant is going to have to disclose. And so that's when you see cases like Ex parte Moody out of Alabama that talk about other constitutional implications that are at issue, such as equal protection, and that an indigent defendant is having to disclose potentially their trial strategies in front of the state when a non-indigent defendant would not have to.
Let me ask you a practical question.
Sure.
Okay, just a quick one. I'm All right, let's say we agree with you and we say from henceforth in Iowa, applications for expert services are going to be ex parte. So you file an application, it's heard ex parte, the judge grants it in part or denies it entirely or denies some of it. Your client's convicted and you appeal. How does the state respond to the appeal?
I think at some point it will be, at that point, assuming that the trial's already happened or guilty pleas already happened, the defense strategy is out in the open and everybody can see it. So I think at that time you can unseal it. I don't think that this is something where we're looking at, pounding it down and it's never going to be opened again for anybody. I think at certain instances like that, or during a post-conviction relief, those records would become unsealed.
Say we agreed that there should be some type of ex parte hearing. Tell me what safeguards you would recommend to protect any of the state's interests, and at what point may a judge say, well, I don't think this is really proper, I want to bring the state in? I mean, tell me how that would play out, or what you're proposing.
I don't know when that situation would happen, Judge, or Your Honor, I don't think that it would ever gets to that point where the state would have an interest into how the defendant is going to pursue the case, what his defenses are going to be, what experts he would like to propose until the time of trial.
What about cost? Supposing someone steps forward and says, let's say it's a complicated computer crime, and I want to hire forensic experts, and it's going to cost $400,000.
Justice Apple, this court has already said that, and it's written in the rule that that's within the discretion of the trial court, and it's upon them.
No, I understand that, but you might want to have some illumination from the people at the Exchequer on the impact of $400,000.
And I think that happens through the public defender's office, because the public defender's office is the one that is ultimately playing the fee claim. And if they have problems with it, there's a specific administrative procedure which will be followed with that. And I cite the admin rule in my report.
But wouldn't it be maybe better then, instead of having an ex parte hearing, because maybe the local county attorney doesn't have a reason to be at that hearing, but maybe instead of having an ex parte hearing, have a hearing where the state public defender can be present to protect the state's interest as the costs and the things that Justice Apple talked about. And even if you disclosed your strategy, at least the public defender could say, well, this is good, bad, it should be paid or not paid. And would that be acceptable in these rules? Because I was bifurcated the cost. It's no longer the state, it's really this public defender system that pays you.
I think that would be a possibility, but I think that would, I don't think that's something that the court can decide. I think that's starting to cross some lines with the legislative authority and what can be done and what can't be done in budgetary analysis. But I would do a comparison to that, in that when an attorney files an application to exceed the fees the statutory fees in a particular case, the public defender's office doesn't have the ability to come in and object to it at that point. It's all done on the back end. And if they want to think that a particular attorney has exceeded or has a necessary...
What happens on the back end, though, if the court authorized it? And we've seen courts authorize it. We have in the last few years, we've had cases where we had to go back in. Even though the court authorized something, we've unauthorized it. The attorney didn't get paid, which is different than some third party not getting paid. And what kind of problems do we create if we don't give them some input when you're doing this, you're making this application?
I don't think it's different, Justice Wiggins. I think it is the same thing, because these experts know that they are getting paid through the state, and they're having to submit these fee claim forms with the public defender's office. So I think that they kind of take that same risk that a court-appointed attorney makes and takes in that type of a situation. And I think that's the nature of the court appointment process and how it works under the rules. I don't think that it'll be any different with it just being an expert witness, and that we should give them more deference in payment of the fee claims, because they can go through that same administrative process that if they were overbilling or overcharging, then they run the risk of being having their fee reducted just like a court-appointed attorney would. I see my time is about to conclude. Thank you.
Thank you as well, Counsel. Mr. Mullins.
Good afternoon. May it please the court. As with so many of my cases, this one started out very interesting until I got a hold of it. Because once I did, I realized that there is something of a manufactured quality to this problem. And I think in support of my proposition that there's no automatic constitutional right to an ex parte hearing in all cases, I think we have to start first by recognizing that there is a conspicuous omission in our rule as compared to the federal counterpart, in that we don't specifically provide for an ex parte hearing with all applications, which is, as I understand it, what the defense would posit, that upon the submission of an application for funds to hire an investigator, that's automatically, if not the application itself is going to be ex parte, then the hearing later would be.
Tell me what interest a local county attorney has in a hearing where a indigent defendant wants to hire somebody to assist them to provide an adequate defense.
Right. And I can tell you that for the most part, experienced prosecutors have no dog in that fight. They don't much care specifically about the disbursement of the funds. But it's a little like applications to fire one attorney and have another one appointed, or applications for continuances and things like that. Once you begin moving along that direction, you begin to see that the state has something of a role to play to ensure that there's an orderly progression of the case. Now, if this were the second or the third application, or we have a litigant who wants to hire and fire attorneys, there's something of a problem where the state may say, you know, we have no difficulty with who's representing this guy, or...
Let's assume a timely application that's not going to delay the trial date. And maybe it will. Maybe they'll come up with something where they need a continuance, but it's not going to, on its face, delay the trial date. I mean, what dog does the local county attorney have in this fight?
Typically very little. And I'm not going to pretend to this court that that county attorneys can or should be getting in there to nickel and dime defendants. That is not our position. Our position, however, is, and oddly enough, I think this defendant was well on his way to getting his expert. The court as much said so. Unfortunately, it's page 6 in the appendix. It's on page 33, and then things kind of spiraled badly at that point, pages 7, 8, 9, and 10. At that point, I don't really think that the prosecutor's problem so much as with the merits of the application. It was with the insistence that it be made ex parte.
Let me ask you, what is the perceived problem or actual problem the local county attorney will have, or the state, if the ex parte hearing takes place?
Sure. Okay. But I think maybe the better way for me to answer your question is to deal with what is required for a defendant to get an expert. And in Iowa, it's a more relaxed standard, and I don't believe that the defense has to show anything more than who, how much, and generally speaking, what is to be required. And in that case, it's self-evident from the minutes. Now, and I don't mean to step over you, but if I could finish, will the prosecution have a problem with it? I can't say, and if it were my view, I wouldn't. But if you accept as you must that Williams and Coker set a relatively relaxed standard for the dispersal of funds, then what's the benefit of the ex parte hearing? And we ought to consider some of the perceived difficulties that come when defendant and defense counsel go walk into chambers.
That's what I want to know. What is the difficulty? I mean, I would assume it's going to be recorded. I mean, it's going to be transcribed, or else you shouldn't have it. I would assume that we can trust our Iowa judges, that if things get afoul, the judge is going to say, wait, time out. We're not here for that. We're here for this. So tell me what the perceived problem is.
Sure. I think what the problem is that as we begin, we are erecting an edifice of procedure that's not necessary. That's one thing. There's a perception, and courts ought to be able to dispel it, but the public is going to see the defendant and his attorney, or the defendant alone, if he's pro se, go walk into the judge's chambers and come back out with something. Maybe he gets what he wants. But if he doesn't get what he wants, now we need to have some kind of a system in place, and we're going to have to project forward, all right, well, what's going to be the nature of review? Is there going to be a court reporting? Who gets to see that? We need to deal with the situation where the cat is out of the bag, at least as far as whoever we find to appoint to represent the state on appeal. Do we need to find a judge who's not from that jurisdiction or that county to deal with it when it comes back on appeal?
First, you have to get discretionary review. And someone has to get discretionary review. And second, when it goes on appeal, I think they've already admitted that the transcript has to be open.
Okay.
For everybody to participate in a reasonable manner. So, again, if things are transcribed and there's safeguards, and we could trust our judges, because I think we can trust our judges not to start talking about the merits of the case and tell these guys how to win the case or lose the case, whatever. I just have a problem with saying anything more. I want the witnesses interviewed, and I want the scene looked at, because these defendants, these counsel can interview the witnesses, but they can't testify. You know, you can't put the guy in the stand and say, didn't you tell me last week you said this? I mean, that doesn't work.
And I maintain that showing satisfies Williams and Coker, Missildine, any of the other cases.
Is there some risk that the two could get mixed up? In other words, as they say they need to do, reveal their theory of defense privately to the judge, they get the benefit of an ex parte presentation of their defense to the judge.
Which is a somewhat different proposition than what I think I guess we have to sort out, well, what's the issue presented? Is the issue presented that the application itself entitles the hearing, the ex parte hearing? Or does there have to be some kind of a showing that in order for me to supply what the court needs, the court has already said, incidentally, it won't grant my application, which is not the problem that we have here. We are still a step or two away from actually seeing if this application would be granted, and I suspect it would and should be. But now, you know, if we're going to if we're going to imagine a circumstance where there's an application but it's inadequate, then I think it is, and that's why we take the middle position, that it's incumbent upon the defense to explain why they have to be more specific than they are. And it's, I think, difficult in a case, and this is going to be this is a domestic abuse case at its core, right? So it doesn't take much to know that, well, or even to say that it would be required to hire an investigator. And what are they going to do? They're going to knock on doors and they're going to talk to witnesses.
That raises my question about so you have this ex parte hearing, and then the defense doesn't get the relief that they want. So maybe the judge just says, this is more than just a domestic abuse case. Of course, it's a Class B felony burglary first, but so if you have a hearing and the judge simply says, no, I don't really think you need it on, let's use your terminology, that it's just a simple domestic abuse, I don't think you need an expert, or even if I do give you the expert, I'm not giving you $5,000, I'm going to give you $1,000, and you're just going to have to live with that, then what's the response?
Okay, and first off, I should clarify that I don't mean to diminish for a moment the seriousness of this offense. It is serious. As many domestic abuse cases start, they quickly spiral into bloody violence, as this one did. So I don't mean to diminish it in the slightest. But Your Honor does raise what I think might be a helpful role for the state to play in this kind of a thing, and a reason why it need not be an ex parte hearing. Because what would happen then if the judge says, no, you know what, 25 years ago, $500 would have been plenty, and I'm not going to give another $15,000 or $3,000, that's nuts. Well, sometimes, and unfortunately, prosecutors have been playing the role of sort of supplying insurance against ineffective assistance of counsel. And so I'm personally aware of instances where counsel for the state says, that is the going rate for things. And so we've now inoculated this prosecution from a later claim of post-conviction relief or on appeal, where we now no longer have to deal with the problems of erecting a procedure to deal with review of a secret proceeding.
It sounds to me that the state is conceding that these people should get an investigator. Can we decide this case by just saying the application on its face does not need an ex parte hearing, so we don't need to reach that issue, and that the court should give them an investigator? I mean, that's what you're telling me. I mean, you're a good attorney. I've listened to you for 10 years, and I could read between the lines sometimes.
Yes.
So can we just dismiss this? Is it yes, a good attorney, or yes, I'm right? We could just decide that, say, remand it, appoint an investigator, and we'll hit the ex parte hearing another day.
It's my position that the showing here was adequate. I hope there aren't too many lines to read between there. It is, in fact, a concession in the brief that we recognize on the merits as presented, that I can't preclude the possibility that there might be some instance in the future where an ex parte hearing might be appropriate. I just don't think that it's appropriate every single time. Because every single time now, if things go sideways, and they commonly do, we're going to have to start erecting a whole procedure to deal with something that's not necessary.
You want to pick your battles, in other words, and this is not one you want to pick.
Oddly enough, as we're taught to do, we're to develop a theme, and the one that I had hoped to use was we don't often get to pick the battle, we get the battle that's been picked for us, and this one was picked for us. But it does have, to my way of thinking, a manufactured quality to it. So,
Well, but it is going to be, the problem with that is that this is and will and can be a reoccurring problem, because my experience has been that you do have certain county attorneys' offices which are going to object to any type of application for a private investigator. And so it is a reoccurring problem. This is just the one in apparently that district perhaps, or that's the tone of the briefs anyway, that takes that hardline position on these things.
which is why I ask this court, as I often do in cases where we're dealing with a procedure, a requested procedure that has some constitutional gloss to it, that it's not been my experience that what happened in Emmett County is widespread. I wouldn't rule out the possibility that there are counties or individual county attorneys that might, as a blanket matter, decide they just don't want defendants to have investigators. So why create a system that serves few and creates a variety of problems for all the rest?
Well, you look around the country and most other states have some sort of system in place. Are we unique and different in some way?
I couldn't reliably tell you, but what I can say is, as we often do in questions of procedure, for lack of a better expression, there's more than one way to, there you have it. So it's for that reason that I think if the legislature wished, or if the Rules Committee decided in a collaborative process that there's something unique in Iowa that requires a structure, an ex parte hearing, or maybe would set the standards for when an ex parte hearing is required, that's an issue for another day, and I'm not prepared to express much of an opinion one way or the other on that, given as it's unformed. But what I do think is interesting, and this is the part of where I saw the fascination of this case begin to ebb for me, and that is when you get your issue of first impression in Iowa and a split of authority elsewhere, you know, it's kind of like Heisenberg's principle, you know, the more you look at it, the less you understand. And here what I understand is that there are some jurisdictions, their legislatures or their rules committee have set it up as a rule. There's a smaller subset which say, for constitutional reasons or other reasons, we're going to require ex parte hearings in all cases, or sometimes. And then you could also characterize it as saying that there's an equal number or a significant plurality of states which say, no, you never get it, or if you do, you don't get it as a matter of right.
I'm intrigued by your argument, as I often am. Let me just raise one other question about your suggestion, concession, what have you. Wouldn't we have to overrule Williams? Because they really haven't made anything different from the showing we said was inadequate in Williams to obtain the expert services.
You know, I have sometimes been accused of reading cases in a fashion that advances my own interests, but here I would say that there's nothing or there's little about Williams that the defense didn't meet here. I don't understand Williams to mean anything more than that a statement of who, how much, and generally the area to be explored.
Looking at the language that says the court, this is what we approved, this is what the court below did. It suggested that the application was inadequate in not advising the court as to the number of investigators to be employed. That was done. Area to be investigated, that was not done. And the probable cost or rate of pay, that was done.
Mm-hmm.
So isn't the middle piece maybe the piece we're overruling?
No, because I think, and it wouldn't be the first time I didn't understand the question. As I understand it, what happened here, and maybe the defense said, I'm not going to talk about the area to be explored, okay? But remanded, if you wish, I think it's self-evident when you said, I want to hire Terry Klooster, he costs $3,000. This is a domestic abuse case that went very badly. What is it that the investigator is going to do? He's going to knock on doors, he's going to talk to people, or he's going to do the electronic equivalent of it. There is no mystery here. Now, maybe defense counsel knows more than that, and there's something special that defense counsel knows, okay? I don't think he has to disclose it. I think just what I told you is minimally adequate to obtain the services of an investigator. And for those reasons, we respectfully request that this court affirm the decision of the district court in declining to entertain an ex parte hearing on the defendant's application. Thank you.
Mr. Mullins, thank you as well. Mr. Sease.
Thank you, Your Honor. I think I would be in agreement with Justice Mansfield that I think you would potentially have to overrule and overturn Williams in order to just do a simple remand. And I wouldn't have a problem with that because I think it creates a broader allowance for experts in what needs to be disclosed. But I think that you still run the risk of, at least in this specific case, not in this specific case, but in the more general sense with this court has the ability to address a more general issue for something other than just private investigators. And the rule of criminal procedure that allows this, the appointment of expert witnesses and private investigators speaks broadly, and I think this would give the court the opportunity to address that. One thing Justice Wiggins had been asking, what was the point and why did the county attorney want to be there? And in page 10 of the transcript, it specifically stated that my fear is this investigator's job is going to be to dig up more dirt on the victim and present that to her during the deposition to the point where she's not going to be wanting to cooperate in this prosecution. That is the problem with allowing the state to participate in these types of hearings, is that they are advocating for how it's going to hurt their case if you allow it to go forward. And now the county attorney has the ability to adjust his prosecution based on what knowledge he has gained from filing these applications. And that gets to the heart of why we think it's necessary to have that broad, absolute right for an ex parte hearing. And for those reasons, we'd ask that the court reverse the district court and follow the majority of states and allow for ex parte hearings. Thank you.
Thank you, Mr. Sease. Mr. Sandy, did you wish any time to sum up any arguments?
Judge, nothing other than just to say that I think Justice Mansfield had asked a question earlier on during the argument why more specifics weren't provided. And you can read in between the lines with my statement that as trial counsel at that time, I have information that if I get into why it's relevant, what the connection is, I'm going to be tipping my hand, number one, as to where I'm going with that. And it is relevant to a burglary charge, just not a domestic. And two, Judge, I think that something that hasn't been brought up is that there's an inculpatory nature of the work I'm doing. See, a reciprocal discovery agreement is only triggered if I plan on using it at trial. An expert's report I'm only going to use if it's beneficial to me. But by having this open hearing and talking about who I'm hiring, why, what areas they're going to get into, it could actually hurt me if I plan to not utilize those experts or those investigators or those witnesses. And that's the exact reason, Judge, that I think that there has to be an absolute rule for an ex parte hearing so that I can freely have these discussions with the judge. And I don't mind telling the district court judge, well, here's what I'm thinking and here's where I'm going to go with the case. And here's where, if I look, it's just not a fishing expedition, Judge. Here's why I think it's relevant. Here's how I plan to present it to a jury and why it would be helpful. I can't freely have those discussions with the district court judge when the prosecutor's sitting there writing everything down. Or even at that point, knowing whether I'm going to take depositions and have to disclose a witness list. So I do think that this is the chance for the Supreme Court to address this issue. And I can tell you that it is happening in more and more counties where I'm getting resistances and I'm having a resistance just for the purpose of the prosecutor showing up to have this discussion take place and then withdraw their opposition. Okay, we're fine then. And so I don't think Coker or Williams stands for the proposition that I just have to say who I'm hiring and how much they cost. It's not what the cases say. I have to get into specifics as to why and create a nexus between why it could lead to an exculpatory theory. That's the nature that Williams and Coker require me to do.
But couldn't you say in the application, your application says complete his investigation. Couldn't you have said, as I think the state is conceding, to interview witnesses and look at the scene?
I did.
No, here's your application. Expected the cost Mr. Coker to review the file, complete his investigation, and write a report.
No, the transcript, Your Honor, specifically states, if you look at the transcript for the hearing that we had, I told Judge Courtney, I want an expert to interview witnesses and to do these types of investigations. I told him that.
What more does the court have to have then? Why do they have to have what they're for?
Because that's what Williams and Coker says. I don't have the case in front of me. Read verbatim what Williams and Coker says. It says I have to get into the area and connect that area as to why it's relevant and why it could lead to an exculpatory theory that I have. That's what the cases require. And that's why Judge Courtney ruled the way he did.
Thank you, counsel.
Thank you.
Case of State versus Dahl then is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.